what's a county to do? Here's just some of my thoughts on the benefits and drawbacks of each of the different paths. So the benefit of the Public Service Commission path is that it's easy and cheap, because you probably don't have a CREO right now, and you might not have a workable ordinance right now, and so you don't have to change anything. Like a developer, you don't have to pay to have your ordinance changed. And you can also push the controversy to the state. A CREO, the benefit of a CREO is, first of all, I'll just tell you, developers want people to have CREOs. If you have a CREO in place, you are wanting to attract developers to your place, because effectively they are held to the very same standards as the state, but they are not having to conform. They have to get that answer from you quicker, because you have 120 days and the state has a year to give them an answer, and they don't have to conform with the labor requirements that the state is requiring. They also don't have to pay the intervener funds. So developers would love to work with communities that have CREOs. So if you want to attract developers, the CREO is the right path for you. It also is the only way that you can 100% assure that that it's your local government that's going to have a say on the proposal, on the project proposal. Because again, if you have a CREO and all of the local governments in the region, in the proposed project have a CREO, that's the way you lock the developer into that. The benefit of the workable path is it allows you to have give voice to your local preferences, but I would have the caveat, like, within reason, right? Because you can't be obstructionist, or otherwise the developer is just going to go to the state. The other reason to do this is if there's something that you care about that deviates from what might be allowed to be in a CREO, if you don't call it a CREO, you don't have the penalty that you would have if you ultimately have to deny that project. So that is the other reason to effectively have a workable ordinance. The other thing that's happened that's not in the law but is like layered onto this is that there's also now more money for local governments who approve projects at the local level. So whether you have a CREO or you have a workable ordinance, the state government now is paying $5,000 per megawatt to those local units, compared to the $2,000 that goes through the Public Service Commission path. So there's some additional financial incentive to do something at the local level. And this is the other reason why developers may well want to work it out with you, because the state has to pay that money, not them. If they go through the state level process, they have to pay the $2,000. If they can work it out with the local government, the state's going to pay that money. Okay, there are drawbacks, though, of each of these paths, too, from the local government's perspective. So at the Public Service Commission level, right now, there's nothing in the law that says that they even have to look at your local zoning ordinance or your land use plans, right? And so there's less of an opportunity for you or your constituents to influence the outcome. Again, going through the CREO path, you have the final say, but you don't have an opportunity really to establish the local requirements. In order to be compatible, this is set in the state law. The drawback of the workable path is that there is no guarantee that the developer is not just going to go to the state and find you unworkable. And what could be workable for one developer may not be workable for another developer. And that is the risk of the workable ordinance.